explain them to you?
Yes, sir, I have time.
All right. And did you notice on paragraph 12B on page 4 of 6 of each of these documents that each of these offenses alleged involves a second-degree felony offense, and that if convicted of a second-degree felony offense, you could be punished by confinement in prison in TDC, Texas Department of Criminal Justice, the Institutional Division, for a period of no less than 2 years, up to but no more than 20 years, and a possible fine in each case of up to $10,000.
Yes.
Do you understand that possible range of punishment?
Yes, sir, I understand.
And attached to the end of each of these plea packets is one or more pages that begins as Exhibit A, and it's attached to the plea packet and incorporated therein. And each Exhibit A to each of these plea packets is a copy of the indictment that the grand jury presented against him. Do you understand that?
Yes, sir.
And in clause numbers A2345, A2346, A2347, and A2348, the grand jury has indicted you for the second-degree felony offense of intoxicated manslaughter with a vehicle. Do you understand that?
Yes, sir, I understand.
And in A2345, A2346, and A2347, those indictments also allege a deadly weapon having been used, which was specifically a motor vehicle. Do you understand that?
Yes.
Mr. Robles, in A2345, how do you plead?
Guilty.
And to the allegation of a deadly weapon, how do you plead? True or not true?
True.
And in A2346, how do you plead?
Guilty, Your Honor.
And to the deadly weapon allegation, how do you plead?
True.
And in A2347, how do you plead?
Guilty, Your Honor.
And to the deadly weapon allegation, how do you plead?
True.
Then we come to A2348. And that also involves a second-degree felony offense of intoxicated manslaughter with the vehicle. However, it appears the state has moved to abandon the deadly weapon allegation in that indictment. Is that correct, Ms. Wilkie?
Yes, Your Honor.
Mr. Stedman, is there any objection to the abandonment of the deadly weapon allegation in this indictment?
No, Your Honor, it's part of the plea agreement.
And then, Mr. Robles, to this indictment, alleging again the second-degree felony offense of intoxicated manslaughter with a vehicle without the deadly weapon allegation, how do you plead?
I plead guilty, Your Honor.
And then, Mr. Robles, we have in cause numbers A2349, A2350, and A2351, those offenses involve also second-degree felonies offenses, but they are of the aggravated assault with a deadly weapon. Are you familiar with these allegations?
Yes, sir.
Do you understand these allegations?
Yes, sir.
To the allegation in A2349, how do you plead?
I plead guilty, Your Honor.
And in A2350, how do you plead to the same offense?
Guilty, Your Honor.
And in A2351, how do you plead?
Guilty.
Mr. Robles, you have pled guilty to each
And then in A2349, A2350, and A2351, it's been explained to Ivan that by operation of law, there is a deadly weapon fine in those cases.
Very well, that is true, Mr. Robles. Do you understand that?
Yes, sir.
So these do involve an affirmative finding of the use of a deadly weapon.
Judge, before you pronounce acceptance for judgment,
yes,
I inquire of my client.
I certainly will. Let me get a little further, and then I'll do that. Mr. Robles, you have pled guilty to each and every one of these offenses. Is that correct, sir?
Yes, sir.
Have you pled guilty because you are in fact guilty and for no other reason?
Yes, sir.
Have you pled guilty freely and voluntarily?
Yes, sir.
Have you pled guilty knowingly and intelligently?
Yes, sir.
Mr. Stedman, do you believe Mr. Robles is competent to enter these pleas of guilt and true to the deadly weapon allegations?
Yes, Your Honor, I did.
Very well. Do you want me to ask about the plea agreement, or do you want to go first?
I'd like to go first.
Go ahead, sir.
Ivan, based upon our situation and the communications that you've had with myself and Mrs. Keener, do you feel that Mrs. Keener and I have answered all your questions regarding the pending cases, preparation of trial, and the plea agreement?
Yes, sir.
Okay. Were you satisfied with the manner and way you communicated this with your family members and yourself?
Yes, sir. I'm satisfied.
Okay. And do you feel that we effectively answered those questions and investigated this matter on your behalf?
Yes.
Okay. So based upon that, Ivan, did you enter this plea freely and voluntarily of your own accord.
Yes, sir.
This is your decision,
Yes, sir.
correct? Okay. And at all times in preparing for trial, we were getting ready for trial in about 3 weeks, correct?
Yes.
And we told you at all times we were ready for and preparing for trial. We actually had our witnesses on our witness list, and we were getting ready to subpoena our witnesses. Is that right?
Yes, sir.
And then you informed us that you did want to consider it a separate plea. Is that correct?
Yes, sir.
Okay. Are you satisfied with legal representation of the way this process has gone and the way we've enacted to protect your rights?
Yes, sir. I'm satisfied.
So, Mr. Robles, you do understand that you have an absolute right to have a trial by jury? Do you understand that?
Yes.
Okay, and is it your desire to not exercise that right and to instead enter these pleas of guilt?
Yes, sir.
And Ms. Wilkie, is there a plea agreement in this matter?
Yes, there is, Judge, and I was waiting sure the defendant was on camera. He did enter pleas of guilty on 349.
That's correct, he did.
All right, Judge, the terms of our plea agreement are this. He is, in exchange for his plea of guilty, the defendant is going to plead guilty in all of the cases, A2345 through 351, as indicted, and will be subject to the full punishment range, which is 2 to 20 years confinement, and that's a $10,000 fine in each case. The terms of the plea agreement are that A2345, 46, 47, and 48, the intoxication manslaughter cases can be stacked, and the state will be asking the court to stack those. A2349, 350, and 351, the aggravated assault cases will run concurrent with each other and with A2345. They're also part of our plea agreement is that the defendant is waiving his right to appeal both on guilt, innocence, as well as punishment.
And there is,
I don't know if I heard it, but the deadly weapon finding was abandoned in A2348.
That's correct.
And that is our agreement on the plea agreement, Your Honor. And the state has made it very clear that they're requesting consecutive sentences, and of course we are against that.
and I was told earlier but didn't hear it on the record that there is also no cap or limit.
Correct, Your Honor. He's subject to the full punishment range on all cases.
All right. Mr. Robles, do you understand those terms of the plea bargain agreement?
Yes, sir. I understand.
You understand that in each of the 4 intoxicated manslaughters that, again, there's a 2 to 20 year range, and that those cases could be stacked, whatever sentence is imposed could be stacked and run consecutively, one on top of the other.
Yes, sir. I understand.
And that in the 3 aggravated assault with deadly weapon matters, that those would run concurrently, whatever sentence is imposed, and they would with each other, and then they would also run concurrently with A2345.
That's my understanding.
Do you understand that, sir?
Yes, sir. I understand.
And do you understand that with affirmative findings of deadly weapon, assuming Mr. Stedman explained the impact that has on parole eligibility?
Yes, sir.
Is that correct, Mr. Stedman?
I have, Your Honor.
All right. And that there is no cap or no upward limit on whatever sentence could be imposed.
I understand it's exposed 2 to 20 years on each of the apprehensions.
So all told, the potential range would be what, you believe, Mr. Stedman?
Based on my math, Ms. Wilkie can correct me if I'm wrong, the minimum would be 2 years confinement in the state penitentiary to a maximum of 80 years confinement, with one of the cases not having a deadly weapon finding.
Do you understand that wide possible range of punishment, Mr. Robles?
Yes, sir.
And you still want to persist in entering this plea of guilt?
Yes, sir.
All right. Mr. Robles, the court will find that you are competent to enter a plea of guilt, that you have entered a plea of guilt, that there is sufficient evidence to substantiate your plea of guilt, that you've done so freely and voluntarily, knowingly, and intelligently, and the court will accept and receive your pleas of guilt and take them under advisement at this time. Ma'am?
No, I didn't take
I thought you did. We are going to then reset your case for a sentencing hearing. And Mr. Grona, Mr. Grona is with the probation department, and the probation department will prepare what's called is a pre-sentence investigation report, sometimes referred to as a PSI or PSR. It's an in-depth report, a background study on you, your criminal history, your educational history, your social history, your family history, just everything about you.
Just for certification, within the confines of the admonishments, we did strike the waiver of the PSI. You
And so the rules require that everybody get a copy of the PSI at least 10 days before the sentencing hearing. Mr. Stedman will get a copy. I'm sure he'll provide you a copy. Ms. Wilkie will get a copy. I'll get a copy. We'll all read it. And then on January the 19th, that'll be our sentencing date, January the 19th of 2022 at 9 a.m., we'll have a sentencing hearing on that date. The first thing we'll do is we'll take up whether there are any objections by anybody to any of the information in it, whether there are any additions that need to be supplemented into it or anything that needs to be taken away from it or any corrections. And once we've covered that, then both sides, the state and the defense, are entitled to call witnesses, put on testimony and evidence and exhibits, and argue for whatever they think the appropriate sentence should be. And at that time, considering all of that, the court will determine your sentence. Yes, sir. You understand the process?
Yes, sir.
All right. Part of the process is that you would be interviewed by the probation department. You have the right to have your counsel present during that interview, right? That I'd be present. All right. So, Mr. Grona, would you please coordinate those interview dates with the defense counsel? Thank you. All right, Mr. Stedman, Ms. Wilkie, is there anything further this morning?
Your Honor, I would just ask that the court admonish the defendant that after he walks out of here today, he can't change his mind about his plea because the court has taken the matter under advisement. Just want to remember that right now.
Judge, I've made that crystal clear to Mr. Robles. I mean, he understands this was a decision if he was going to make it. He had to make the decision. There was no coercion. I explained to him that once it's entered, if he has any pause or he's thinking now he needs to inform the court now that he does not wish to have these entered, that we can proceed to trial. I don't even
I'll proceed.
That's right. So, Mr. Robles, no buyer's remorse, no takebacks, no change of mind. If this is what you want to do, you can do it, but you can't change your mind after we're done.
Yes, sir.
Do you understand?
Yes, Your Honor, I understand.
And do you want to move forward with these pleas?
Yes, sir.
Very well. Ms. Wilkie, one last thing. What between now and January the 19th of 22 at 9 a.m., what will happen if Mr. Robles commits another offense?
Yes, Your Honor, that's what I was going to say next. It's in our paperwork. It's standard that if he commits an offense between now and the time of the punishment hearing on January the 19th, that he would be subject to the punishment range, which he already is. But the caps of the stacking agreement would go away and he'd be subject to stacking on all of the cases.
He's not on bond, Judge. He's been continuously in custody since January of 2020. He hasn't had any problems.
He hasn't, Judge, had any problems, but he still doesn't want his jail. If that were to happen, then he's subject to stacking on all of these constitution and so on.
I've explained that to you.
Very well. Mr. Robles, do you have any questions, sir?
No, Your Honor.
Anything further from the state?
Nothing from the state, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, Mr. Robles, then that will conclude this hearing, and we will see you back in court for a sentencing hearing on January the 19th, 2022 at 9 a.m.
Yes, sir.
You may be excused.
I'm sorry, we put on the record, that is going to be in Kerr County.
In Kerr County.
Yes, Your Honor. That's our request. We would want this in Kerr County based upon our request.
And is that a Kerr County date?
It is, Your Honor.
All right, then that'll be in Kerr County, Mr. Robles.
So we haven't informed the court. We believe it's at least quarters of a day.
Okay, 3/4 of the day.
Yes, sir.
Just
I
keep
would
that
think it'll take a full day.
full day.
Yes, Your Honor.
Okay, well, we'll take whatever time is needed, but thank you for the heads up about that. All right, you may be excused.
Thank you, Judge.
All right, Mr. Galvan, the court will be in recess for a bit. I've got a bunch of papers to sign here, and then we'll take up your